Looks like about ready to start here, about 12:03. So I want to stay on calendar here. My name is Christy Arkovich. Those of you who are members of TBBBA, you probably have watched us before, a number of different things. This is for consumers, so we always try to emphasize a debtor's bankruptcy practice from a consumer perspective. Next month, we have scheduled for foreclosure, forbearances, moratoriums, what's to occur on how to extend them, the expirations, and so forth. Mike Wazalik up in Pasco does quite a bit of that. He's a local Jedi attorney. I think, Brian, you know him as well. And so he's agreed to speak. And so that is the first Tuesday of the month in December. We do have CLE credit for Brian's presentation today. I'll repeat it at the end, but the credit is 200-727-5N. So that's 200-727-5N. So today we have Brian Shrader. I've worked with Brian for a number of years in various consumer class actions or FDCPA type work. Brian was a former prosecutor. I didn't know him back then, but he did that for a number of years. He has since been with, I think it's Dunlap and Bennett, as well as Gus Centrone. Now you are the founder of your current firm, Shrader Law. And so he specializes in business litigation, personal injury, consumer matters, and really focuses on a class action perspective. And that's how we've worked together in the past on a number of class actions. And I thought that would be a really good topic today, because a lot of our actions I don't look at right away with a class action view, and I think that's very helpful for folks to clue in on. So I'll turn it over to you. I'll go ahead and share screen now. And sent me the PowerPoint we'll have before here. All right, there we go. So Brian, it's all yours. Thank you very much.
Excellent, thank you. And thank you for everyone for attending. And Christy, you can go ahead and go to the next slide. The goals of the presentation, and really my goals in speaking to you guys today, is to assist you guys in identifying potential class claims, and then also identifying what class claims are viable and what are not. And this really all starts from very early in my career. When I left the prosecutor's office, I left the economic and white collar crime unit. I had been litigating on kind of banking related cases and insurance related cases, and I was looking for a practice that was somewhat similar. And it turns out prosecuting consumer claims is pretty spot on for being comparable to what I was doing as a prosecutor. And so during the course of the presentation today, I'm going to talk about a lot of the cases that we've brought, a lot of the cases we've actually litigated. I want to share a lot of that experience with you. I'm hoping to spark some curiosity in these type of claims, to demystify class actions and what they mean, and to make them seem more accessible to everyone. Because I think as debtors counsel, you're sitting on a lot of claims that you may not realize are viable from a class action perspective, that may not be viable from an individual claim perspective, or maybe not very appealing from the individual claim perspective. If you want more information about any of the cases I talk about, please contact me privately. I'm going to have to be somewhat careful in what I say about some of them, because there have been settlements, there have been confidentiality agreements, there have been non-disparagement issues, and so I will be speaking very factually about them. But if you want any additional information or access to the filings or pleadings or briefings, please let me know. I want to make sure all of that is available to anyone who wants it, so that everyone can see whatever they need to see from the docket, or ask me anything they want to ask in a private type situation. So starting with consumer protection work, and why I get so excited about it, and why I think everyone should be excited about it, is that it really gives us a chance to hold businesses, banks, corporations, employers accountable for their actions. And in working with debtors over the years, and even representing trustees over the years, I've heard really horrible things. Banks who are calling up saying, if you don't pay your credit cards, we're gonna have you deemed an unfit parent and have your children taken away. And we're gonna, I remember one getting a recording where there was a lady speaking to a debt collector on the phone, and her dog was barking in the background, and the debt collector said he was going to take her dog and sell it to a medical research facility to pay her debts. And of course, those are the cases that never make it to court. Those are the cases that never get in front of a judge. And so it's often the cases that maybe shouldn't have been filed, that are very weak, or cases with questionable factual underpinnings that make it in front of the courts. And so it's real easy for everyone to frown on those cases. And I'm going to talk about some of them at the end of this presentation that certainly fall into that category by no fault of their counsel, because some of the rules changed during the course of litigation. But we're really looking at some pretty horrible things that can happen if these businesses go unchecked. The good news is, in the time I've been doing consumer protection work, which is almost a decade, I've seen a decline in a lot of the abuses. And I do think that is because of attorneys bringing these claims and prosecuting these claims, so that these entities are held accountable, so there's a financial price tag associated with it, and to act as a deterrent. So, I think there's a lot of good will that comes out of doing these cases. There's also a lot of financial upside to doing class actions. And I don't think that's something we need to avoid acknowledging, in that we can all make a lot of money in these cases, as opposed to some of the individualized claims that maybe don't support attorney's fees and the amounts we'd be seeking, or don't support even the ability to bring a claim from an economic viability standpoint. So my first class action, and Christy, if you want to go to the next slide, my first class action was actually against Bank of America for trying to collect mortgage debts after a debtor had been through a bankruptcy and the debt had been discharged. And I had really never thought about class actions from a consumer standpoint. It seemed like something very far away, something very complicated, something we couldn't afford to bankroll from just starting a new law firm at the time. And so I really hadn't thought about it too much. But when I saw this correspondence from Bank of America and I started thinking about it, I said, well, this is going to be the same letter to every single debtor. This is going to be the same bankruptcy discharge notice being sent from the court to every single debtor. This seems pretty standard. And so a class action lawsuit is an opportunity for people of the same or similar injuries to bring a suit against the defendant as a group. And the general theory is that that individual claim may not be worth a lot of money, although I beg to differ, and certainly we've brought those on an individual basis, but sometimes those types of claims aren't worth a lot of money. And so if we compile them all, we can consolidate the legal costs, consolidate evidence reviews, witnesses, the court's time and resources to make things more efficient. And I go ahead and put here, if anyone is interested in looking at really boring rules of procedure, it's Federal Civil Procedure Rule 23 and Florida Rule 1.220 that will give you at least a glimpse into the procedural aspects of what it takes to bring some of these. Christy, if we want to go to the next slide. So, procedural differences with class actions. And this is where it can be very difficult if you don't understand all of the steps to navigate, because the rules don't lay it out very clear. Class action starts with a complaint, and that a complaint will assert the claim on behalf of a named plaintiff, let's say John Doe class representative, but it will also assert the same claim on behalf of all similarly situated individuals, and that's kind of a key phrase. Not all class members need to be identified. At the time you bring the complaint, you don't even need to know how you would identify all of those class members. You just have to generally identify how you would identify the class. And so, all people who've been through a Chapter 7 bankruptcy received a discharge, and after discharge received correspondence in substantially the same form as attached Exhibit A. And so you have to outline what the class definition would look like, but you don't have to identify the actual individuals. We make the defendants tell us all of that. Now, prior to filing the complaint, what's very important is I like to have what I refer to as my class action pep talk with the class representative. And this means when we talk to the debtor or the potential plaintiff, we want to talk to them about what responsibilities they're going to have when they bring a class action. Because these cases aren't something just to kind of shoot from the hip. These are things that should be taken very seriously. And we're going to see a lot of very hard-fought defenses raised. We're going to see usually bigger firms with very high caliber attorneys who can be very creative in coming up with defenses. And so before I put forth my firm's resources, and before I take up the court's resources, and candidly, before we let the defendants spend any resources. We want to make sure that we have a very serious individual on our side as a class representative. They have to be very stable under pressure. They have to have at least some ability to comprehend what's going on in the case. They have to have an inclination towards being able to make decisions that would benefit the class and not just their own interests. And they have to have the wherewithal to survive the litigation. Now, that's not to say this is really much more work for them than any other plaintiff. They'll have a deposition. They'll have to attend a mediation. They may have to answer some interrogatories. All of those things are pretty uniform, pretty common. But the questions they're asked are going to be questions about their understanding of the lawsuit, about the understanding of their role as a class representative. And we need people who are going to be able to listen to us and answer those questions in at least a coherent level of understanding. Otherwise, they'll be deemed to be inadequate as a class representative. And I'm going to talk about that in a second. Once the complaint's filed, there'll usually be class discovery. Class discovery is usually conducted before individual merit discovery. And so we'll actually have an opportunity to examine how many people meet our definition, whether we need to tweak our definition, and you can actually tweak the definition of your class, how you outline your class all the way up through the motion for class certification. But this class discovery will get into how many people had similar situations, and that will maybe be very involved. Often defendants are hesitant to turn over that type of information because they know the liability it's going to create for them. And so it can be a rather contentious period. Then there's a motion for class certification. And we'll talk about the elements of this motion in a minute, but this is asking the court to certify and issue an order that yes, a viable class does exist, that is ascertainable. This is the parameters that define that class. And from that point on, once that class is certified, we no longer represent an individual. We can't go backwards in time. Our client is the class. And so it can really change things from a negotiation standpoint. And this is usually the point of time where defendants will settle because they recognize the huge liability going forward to a trial. There will be notice to class members. That will happen after a class certification or as part of a settlement process. Notice can be sent, the postcards that people see in the mail. It can be published. We usually have a website that we pay to put up for people to go to for questions. It's interesting to me that courts don't really require actual notice. It's just kind of, hey, do something reasonable in light of the circumstances. And if someone doesn't know, too bad. As long as we satisfy that prong, though, class members will be subject to the release or to the judgment, whichever resolves the case. So notice can be very important. It's also an area where we believe there's some abuses or some neglectful conduct by some plaintiffs' firms who are trying to cut corners. So always have to be very cognizant of the notice provision. And then finally, something that's very different about a class action is that the court has to approve the settlement. And there's a very long and sometimes complicated settlement process. At the settlement stage, if the parties do reach a class action settlement, sometimes courts refer to it as the love fest. And I feel like, defense counsel and plaintiffs counsel hold hands or lock arms and we sing songs together and toast each other and how wonderful we are and how great a job we did, because we will usually reach an agreement that will not only benefit the class from one side of things, but the defendants are often very interested in the great big class release that says no one can ever sue them for this type of conduct again. And so we've locked into an agreement and we are going to the court together to try and get the court to approve that settlement. And so it's often very strange to hear defendants arguing how, they've really locked down this settlement and something very favorable to their client, and hear plaintiffs' counsel say how this is very favorable to the class. And sometimes we end up arguing each other's cases for them because we say, well, we couldn't ask for more from the defendant, Your Honor, because our case really had a lot of weaknesses. And the defendants say, well, Your Honor, we really had to settle for this because the plaintiffs were really going to nail us. And so it's a very strange procedure sometimes when we first walk into that. But it's all public. And there will be options I'm going to talk about for the unnamed class members who are getting notice of a settlement. We'll talk about what their options are in this type of a situation. So Christy, if you want to go to the next slide. So common issues for debtors counsel, and what I've tried to do here is spark your interest in some things that you probably see on a regular basis. And please, I'm not trying to pitch my firm. If you have other counsel that do class actions, if you see these type of things, take them to those attorneys and say, hey, will you look at this? Will you examine this? Will you tell me what you think about this? Because I truly believe debtors counsel is in a great position to find these types of cases, really for three reasons. One, you've got very susceptible clients. They're signed up for a lot of things. They have debts. They've been consumers. They're out there in the marketplace. Two, they're often dealing with large corporations, and large corporations operate with forms, with standard policies and procedures, and with things that are very uniform, that are very good for class action practice. And the third is that usually your clients are at odds with those companies. And so the predatory nature of those companies has come out. We get to see the ugly side of things. This isn't their happy marketing, come in, buy our product, sign up for our credit card account side. This is their, you better pay us, or hey, we're going to come after you, or any other type of predatory adverse action is usually happening to a debtor when they find themselves in a tough situation where they're maybe considering bankruptcy or going through a foreclosure type situation. And so I'm going to touch on a couple of them before we go. I'm going to do individual ones, but I didn't do individual slides. For the first one was usury. It's somewhat self-explanatory. If you see debtors coming in with accounts and they have usurious interest rates that are over the statutory, limits, please send it to a class action lawyer. Those cases are usually incredibly simple, incredibly straightforward, when we can get a lot of money back out of the defendants to recirculate to the consumers that have been abused by that. And so those are very interesting cases. The other one I didn't put on here was just because I had forgotten until I was reminded by my co-counsel, Catherine Yanez, the FCRA Fair Credit Reporting Act. If you have clients that are having their credit report pulled for inappropriate purposes, that's something we're always looking for. There was a wave of them. We're not seeing it as much anymore, but it's certainly something where if you have credit reports being pulled for unauthorized uses, we're always interested. So why should you guys be looking for this? And I know I touched on it, that you guys probably see a lot of these things or have a lot of these things pass through your offices. The number one reason I'm going to go ahead and tell you is you can increase your revenue. This increases the value of a claim, not just for the plaintiffs, which it certainly does, but also for you. And the example I'll give is a typical FDCPA claim may settle pre-answer for $4,000. If you attach a class allegation to it, it is not uncommon for us to settle those pre-answer within a week or two of filing for $10,000, $15,000, because the defendants understand the risk to them and understand what they're about to have happen to them if we get into class discovery. Now, that's not to say we do that on every case just to try and get more money out of a defendant, because we want to make sure, like I said, we have the right plaintiff. We talk to the plaintiffs ahead of time, make sure they understand what's going on, that they have the wherewithal. We also want to make sure we have the right type of claims to survive what tends to be a little bit higher caliber defense that's fired at them. But if we have those things, even if it's decided, hey, I was just offered a bunch of money and I want to take it, and the class representative decides, hey, I just want to take this settlement, it's almost always a higher settlement than we would get on a case that doesn't make a class allegation. And if we do that, usually the only thing that's different about the settlement is that the defendants will ask us to certify we don't have another class representative already signed up. So we're always very careful to only sign up one at a time. And so, think about the increase of revenue, think about sending these claims, either filing them or bringing in a co-counsel to file them on a class basis, because it will increase what your client recovers. It will also increase what you recover significantly. Another reason, and I'm going to harp on this again, is it's an opportunity to do a lot of good for a lot of people. And we'll talk about some of our class settlements that we've received here shortly that I think will shed some light on what I mean by that. And Christy, if you want to go to the next slide. So I'm going to start talking about some actual specific examples of things you can look for, things that we've litigated, things that we've looked at. And the first one is the WARN Act and employment issues. And the WARN Act is something that was rather new to me until a few years ago. And the long and short of it is, if you have mass layoffs at factories or call centers or other large facilities, employers are required to give a lot of notice, and they're required to pay wages through the notice period. Also, in mass layoffs, you usually have employers who never pay final paychecks. And so we had a case, Amati Home Healthcare, Amati versus Ace Home Care versus Joy Barlin. This was a large healthcare company that shut down here in the Tampa area. There was really no notice. They didn't pay their last round of paychecks. And because they were nurses, it was really compelling because the nurses didn't want to just stop going and caring for these people when the paycheck stopped, because people literally could have died. And so we brought a class case in an employment. They're actually called collective actions. They're slightly different procedurally because class members have to opt in instead of opting out. But we specifically brought an FLSA minimum wage claim, Florida minimum wage, and then unjust enrichment, as well as a few other claims. There was another case that was first filed and alleged the WARN Act violation. That's when I really started looking at the WARN Act issues, and we worked a little bit with that counsel, I think they got a good result. So there's a couple things I want to note about this, in addition to just talking about the big issue for the slide. First is what do I mean by first filed? What I mean by first filed is that in class action practice, it is a race to the courthouse. The first person that files a class action against the defendant for whatever the type of conduct is in control, and everyone else takes a back seat and often gets nothing. And so we were second people in line on this case against Ace Home Healthcare, and so we did not get anything because we were second filed. The other thing I'll note is with these employment law issues, we were actually able to sue the officers of the company. And so even though Ace Home Care was going out of business, Joy Barlin was a very successful person and had personal liability. And so that is something that can be very helpful when it comes to at least getting some money or recovering whatever your cost. If you have to dump the main defendant, the corporate defendant, in these type of actions, you can often go after the actual officers. One other thing that didn't arise in the Amati case, but we've seen in employment issues here locally, is background checks. We had a big telemarketing firm set up. They needed to hire, as far as we could tell, maybe 200-300 people very quickly. They sent out some applications. Basically anyone who filled it out, whether it be in crayon or just put smudged fingerprints on it, as far as I can tell, was given a job offer. Everyone started to working, and the people who showed up to work, who actually showed up, were given background checks about 2 or 3 days into working. They went around and told all the people who had something negative on their background check, "You're fired, get out." This is in violation of the Fair Credit Reporting Act, which says if you're going to take adverse action on some sort of background check, you have to give notice, you have to give an opportunity for a dispute process. And this company just said, "Get out," gave no notice, gave no opportunity to dispute, didn't even tell the people what was wrong with their background checks. And so we had not only that cause of action, but cause of action because they took the position that all of these people had committed fraud on their applications for not checking the box about whatever bad thing they found on their background check. And so they didn't want to pay anyone for that time. And we brought that. That was a quick case to resolve, to say the least. So FCCPA, FDCPA correspondence. Why correspondence? Why am I focusing on correspondence? Well, I'll tell a little war story. I'm going to do a lot of that. So it started out, this war story starts out a long time ago with one of my first cases. I was actually representing a trustee. We were suing a large bank, and they had asserted all kinds of defenses. And we were in the middle of the corporate deposition of the bank's representative, and he blurted out that it was their corporate policy that if a debtor says that they're represented by an attorney, that they will simply stop calling for 10 days, and then they just start calling the debtor again because in their minds, that 10 days is enough for the debtor's attorney to call them, and that's the debtor's attorney's problem. And of course, that is not the law. For those of you who aren't familiar, the FCCPA, FDCPA, it says you can't contact them after you have their attorney information. You've got to go through the lawyer unless the lawyer gives you permission to contact them. And so we took that case actually to trial, prevailed at trial against the bank, but because I was representing a trustee, didn't have the opportunity to convert to a class action. I believe I reached out to Christy, and she said, I actually have someone who has servicing with that bank and has a similar experience. And we said, well, if they've told them that they have an attorney and they got a call 10 days later, call us on day 11. And sure enough, we got the call, and we brought the case. You would think that's a really strong class action. There's a corporate policy. We'd be able to flag them all. Unfortunately, the court felt as though there were too many individualized inquiries dealing with verbal correspondence, and this is something we see a lot in FCCPA, FDCPA claims when dealing with some sort of verbal or oral exchange. There's just too many questions about the uniformity of things between class members, and so it can be very difficult to establish a class. These were issues that were also litigated back when the TCPA was alive and well, may it rest in peace. There were some issues with certifying classes on those cases as well when it came to revocation issues and things like that. So what we're looking for in correspondence, misleading letters regarding payment options, regarding statute of limitations. Sometimes it's called zombie debt. If they're saying, hey, we're going to maybe file a lawsuit or something, and it's an old debt that some scummy debt purchaser purchased, or threats about credit reporting. Some correspondence lack the required disclosures. Sometimes this is called the mini Miranda or collection Miranda type issues, or they're misleading about the dispute process. We're looking currently, if for those of you who may see these things, at payoff letters dealing with mortgages. We see a lot of the required payoff letters coming in that are not giving a firm number for what someone needs to pay off, and instead say things like, oh, the number we're giving you is subject to change, and you should call us before you attempt to make a payment. Well, that payoff letter is supposed to have a firm amount for a certain amount of time. And so we're currently looking at those type of issues. I just litigated one on an individual basis and got a pretty good order out of it that supports our theory. We're also looking at out-of-state unlicensed debt collectors or unlicensed practice of law. We see a lot of debt collectors who decide to cross state lines, and in Florida, they must be licensed with the state of Florida in order to be a debt collector here. Similar to attorneys, as we all know, we see a lot of letters coming across state lines, a lot of phone calls being made across state lines as people move. And so we're always cognizant of looking up our debt collectors to make sure they're licensed, because if they're not, then every person they contacted in the state is a class member, and it's a pretty straightforward cause of action. And there's a great 11th Circuit opinion supporting exactly how to structure it, because there's not a specific private cause of action for the licensing issue, but you go under another provision, and the 11th Circuit has given us a great roadmap for that. So for example, a case we're currently litigating, we have a class certified, and we're preparing actually for what appears to be almost definitely going to be a trial. Galls versus Medical Business Consultants. Our client received a letter that said, if you feel that this is not a valid debt, contact us immediately. And it's the immediately that's the issue. A person has 30 days to dispute a debt, and they kind of wanted to circumvent that. The letter also threatens that they report to credit bureaus biweekly, and did so in a way that kind of furthered that you have less than 30 days to really dispute it. But in addition to it being somewhat misleading and confusing, when we got into depositions, we learned that they actually don't report to credit bureaus biweekly. So we've kind of hit them from all sides, and we're hoping that they come to the table, but we'll see. So next slide, post-bankruptcy collections. This one I still get really excited about. I still think these are really good causes of action. There's been some interesting defenses raised as to ascertainability and things like that, but I still think these are great cases, especially when we have form correspondence. So we will bring claims under the FCCPA and FDCPA For debt collectors or banks trying to collect on previously discharged debts or debts who are subject to the stay, we also bring motions for sanctions in the bankruptcy court, or sometimes we just put it in the complaint with the district court. And we bring the sanctions on a class basis. So it's actually a class motion for sanctions. And like I said, we originally started out filing them all just in the district court, asking the district court to exercise its authority to issue the sanctions. We had some judges say, yeah, that's fine. That's totally cool. It's all, the bankruptcy court is just part of the district court, so we have authority. We had some other judges say, nah, I really want you to go back to the bankruptcy court and do it. I always kind of look back on that period of time and think that defendants should be careful what they ask for, because the ones who tried to remove the bankruptcy sanctions portion of the bankruptcy court, we were happy to do so, and then they could litigate on two fronts at once and give us two bites of the apple as to discovery and findings and things like that. And so I think that a lot of them had buyer's remorse for not allowing that claim to simply continue along in the district court. Let's see. The big note here, a lot of people get their correspondence from the debtors post-bankruptcy and they say, yeah, but it has this disclaimer that says, if your debt's been discharged in bankruptcy, this is for informational purposes. Those don't mean anything as long as the disclaimer is overshadowed by the rest of the correspondence. And most of the correspondence we see are exactly the same billing statements that were sent prior to the bankruptcy. They just continue sending them after the bankruptcy. And so the defendants try and say, well, they should know before the bankruptcy this is, an attempt to solicit payment, but after the bankruptcy they should know it's something different. Well, it's the same letter. And so we often find these disclaimers on page 4 in fine print. Meanwhile, page 1 has amount due, please pay, a detachable payment coupon, penalties for not payment listed. And so we've been successful in litigating this issue to show that if those disclaimers are overshadowed, then they are meaningless. And we're familiar that there's an unpublished 11th Circuit opinion that has been waved around by a lot of defendants. It is absolutely factually distinguishable. We absolutely see correspondence sent after a bankruptcy that really is informational only. It is very clearly informational only, and so it is not debt collection. And so two of our cases that settled under this, LaPointe, which we settled in district court, that we were Middle District of Florida only. We identified over 1,500 individual class members, and each class member got $1,500. And so you can do the math on the total pot. I believe it was about $800,000 in attorney's fees that were also awarded in that case, for those of you who are keeping track of those numbers. The second one, Cruzel versus Suncoast, we actually had certified in the bankruptcy court by Judge May as a motion for class sanctions. And in that case, depending on certain criteria, class members had to inform us of whether they met or not. Each class member got between $1,000 and $1,500 per class member. So this is not you get a coupon or you get $20 like a lot of these class actions. We're going for real money and real recovery for people. This was $1,500 in the pocket of people who were a few months out from bankruptcy. I'd like to think that was a little helping hand for them in getting things restarted with their fresh start. So next slide, Christy. Excellent. Debt management over billing. I am almost certain that you all have clients come in that have hired companies to tell them how to pay their debts and what debts to pay, and hey, we'll take care of negotiations for you, and you just pay us and we'll pay them. Well, those companies are very strictly monitored for what they can charge, and all of them overbill. And so we have brought class actions. Most of them settle very quickly. Arguably, when they overbill, it could even be criminal what they are doing. And so we are very successful in getting them to disgorge some of those payments. We also are looking at issues with these companies related to, we know of several large creditors that simply will not talk to them, that simply will not negotiate with them. And we believe they allow consumers who have debts with those companies to sign up under the knowingly false pretense that they're going to be able to do something with that creditor, and they're just not. And so we're very interested in those things. I also think some of these companies, for lack of a better word, are just a little more scammy than others, where they really don't offer any services or any help, and then the debtors end up getting sued from multiple angles. And so we're looking at these companies very closely. Some of the bigger ones we've already hit. Some of them we literally have relationships where they see us coming and they just pay us. And so I think there will be large class actions. I think that these things are going to be brought out in the light. There are arbitration clauses that are sometimes an issue, and I'm going to discuss that here in a moment. But these are very interesting cases for us right now because I think these companies are really taking advantage of people. Next slide, Christy. Okay, Electronic Fund Transfer Act claims. These are also a lot of fun. They can be very straightforward. The long and short of it, and I'm way oversimplifying things, the long and short of it is any withdrawal from a debit card, it can't be a credit card, or a bank account, has to be specifically authorized. And so my co-counsel, Catherine Yanez, had a case. I was not part of it, but I was around for most of it, against SeaWorld, where SeaWorld was basically renewing everyone's annual passes, even though they weren't authorized to do so, and they were just kept on billing. And so instead of it being a 12-month term, they just kind of kept doing it for perpetuity. I believe that one has settled for a very considerable amount of money. The next one is large-scale billing errors. And we're currently working on a case with Disney as the defendant. Unfortunately, they have a defense to this type of claim, but just giving you an idea of what to look for. When they turned things back on for billing people after they had a short break with the COVID shutdown, it billed everyone for all kinds of ridiculous amounts of money that we're not even sure what it was based on, but it was certainly in excess of what the contracts allowed with consumers. And so we're always looking for large-scale billing errors. If somebody has some sort of large glitch or someone just screws up, these can be very lucrative because we can get all of that money back plus fees and overdraft fees and things like that accrue. So I know I'm running short on time. I'm going to try and move a little quicker. Medical billing. I think we all probably would agree that medical billing is a complete disaster from start to finish. One of the issues we looked at very closely, there is an absolute prohibition on billing individual plaintiffs or individual consumers for debts that are covered by workers' compensation. We see hospitals do this all the time. It is something where we've struggled to get set up on a class basis, but we're always looking at, always interested in. We also have billing for medical services never provided. We have a case against a hospital over in Pinellas County right now who was billing for nursery care for all babies, even though all of the babies were being taken to a different hospital and provided services by a totally different facility. And so we believe that there's a lot of billing for services never actually provided. And just as a side note, always look out for key TAM or whistleblowers actions whenever you have medical billing issues, because if they're billing Medicare, Medicaid, TRICARE, stuff like that, please let us know, because those are really fun key TAM whistleblower actions that we can turn over to the federal government and they do all the work and we just cash a check at the end. So false advertising, FDUPA, marketing consumers for services not licensed or offered. We've seen a lot of this with colleges and trade schools saying, hey, you can come to our school and become a nurse. Well, if they don't have the credentials to actually make someone a nurse and actually get someone set up to be a nurse, they're just ripping everybody off. And we had a school in South Florida that we hit pretty hard for this. We're currently looking at a beauty school that was offering a licensed practice type thing that they were not qualified to do. And so this can be very big because entire classes of students will take out student loans and then they're stuck. And so always be looking for those type of false advertising. Similarly, offering prizes not actually available. We were hunting down some car dealerships for a while that were saying, hey, if you just show up and bring this postcard, you'll get a free TV. And we were looking at those type of things as potential causes of action. Data breaches, I think everyone kind of knows what this is. Experian, Target National Bank, a lot of companies had these data breaches where everyone's personal information gets out there. I will tell you, it is a race to file after this information gets out. With the Experian, I think we had our complaint filed within about 72 hours, and we were probably 40th in line. It was really shocking, and it was really shocking how detailed the other complaints were. We were looking just to get something filed as a placeholder, and there were 100-page complaints with complete corporate histories and corporate notes. I just don't know how. And so these are very lucrative. These are sometimes filed by MDLs, and I believe that's the next slide. I'm going to tell you very briefly about what an MDL is. So what is multidistrict litigation? This is similar to class action in that it resolves a lot of claims all at one time. However, what's different is that the way a multidistrict litigation usually started is a defendant will get sued, sometimes multiple class actions in multiple jurisdictions, sometimes just a whole bunch of individual actions in a whole bunch of different districts. And a plaintiff or a defendant can file a motion with the judicial panel in multidistrict litigation, and this is just a group of judges. I think they rotate and they hear cases all over the United States. And they ask the judicial panel on multidistrict litigation to consolidate all the cases in one location. And if they're successful, all of the cases are transferred, whether you like it or not. And even cases that are filed later, a year later, they get transferred as a tag-along case. Usually the defendant just simply files a notice of tag-along. And so you may find yourself at some point filing a lawsuit. You're licensed here in Florida, and boom, now your case is out in California. You're not licensed there. You don't know what to do. The good news is for you, you can't do anything in most of those situations, because if your case has been taken out there, there was usually what's called a liaison or a lead counsel that is actually appointed and approved by the court, and they are the only people who can do anything in the MDL. And so the rest of us find ourselves along for the ride. And those liaison and lead counsel not only can screw up all your plans, but they actually get to take money from your case if you settle it or have any recovery. And so MDLs can be very frustrating, but if you can find yourself in a situation of becoming that liaison or that lead counsel, they can be very, very lucrative, because there will be thousands of cases sometimes. And even if you're only taking 10% or 5%, you're really getting the benefit of everyone else's marketing and everyone else's clients. Some of the preliminary orders, when it gets out to the MDL, will be binding. And so what's very interesting is that if it gets consolidated in a jurisdiction that's very favorable for defendants, sometimes that can mean that certain rules apply that wouldn't have applied where you actually filed the case. So if there's a circuit split, you could get the benefit or the detriment of that circuit split. They can be very slow. Sometimes cases sit for years. And at the end, though, the cases aren't tried. The tag-along cases aren't tried at that foreign jurisdiction. Usually sometime after summary judgment or right before summary judgment, the cases are shipped back to their original jurisdiction, where you get to kind of pick up the pieces with someone else's discovery and try and put the case together. So these can be very interesting. They can be very long. They can be very complicated. And we've seen some real screw ups. For example, there's an MDL right now where liaison counsel was originally appointed who had one of the class actions. As soon as his class action resolved, he withdrew, and the court just never appointed another liaison counsel. And so nothing happened. And it's a bit of a mess at this point. So MDLs, it can be very complicated. And if you're not familiar with them and you have a case brought into one, please feel free to call. I'm happy to talk your ear off about it. Next slide. So identifying class claims, simple things. I tried to put just things out there that you can keep in mind. Any form correspondence sent to debtors, bills, payoff letters, advertisements, feel free to flood my mailbox with them. We literally love reviewing this stuff and finding causes of action. Corporate depositions. If you ever find yourself in a situation of taking a 30B6 deposition, you should always be thinking about potential for class actions, especially with the big banks and big entities. Their corporate reps say the darndest things sometimes in the middle of them, and things come out. Corporate policies and procedures, if you're ever able to get these as part of discovery, we love them. We love combing through them for all the problems. And finally, I didn't put it on here, but if you know what you're looking for, and certainly if you have questions of things to look for, I'm happy to work with you. I know there's plenty of other counsel out there that are happy to work with debtors counsel because we believe that you guys have a lot of these very viable claims. Interview the debtor, just talk to them, ask them about these type of things. Sometimes oftentimes they have no idea what their rights are or what potential claims they may have. And so it's very important to talk to them. Next slide. I'm going to move quickly through the next couple ones. Elements of a certified class, numerosity. That just means you got to have enough people. The magic number is somewhere around 40, it seems. Don't know why 40, why not 50? I don't know. Commonality, these are common questions of law and fact. Typicality, that the plaintiff's experience was typical. Adequacy of your class representative, that they're knowledgeable and willing. Adequacy of class counsel, this is very important. This is somewhat of a barrier to entry for people who've not done class action work before. I was fortunate to be able to team up with Kynes, Markman, and Fellman and Catherine Llanos, who had class action experience, to bring me in. But a court can absolutely deny your class certification motion if they don't think you're smart enough or equipped to handle these type of things, including financially equipped to handle the cost of notice and things like that. And so it's always important, if you're going to do these, have a co-counsel that's been class counsel before, that has been approved as class counsel by a court before, because it's something that will absolutely be part of the equation. Predominance of common questions, and then superiority of class resolution. Those kind of are self-explanatory. General settlement rules, there's a couple buckets, right? There's going to be a class award for all the unnamed class members, kind of the masses. There'll be some sort of bucket of money there. There's going to be an incentive award for the class representative. I put a question mark there because the 11th Circuit just said, hey, in federal court, you can't do that. They recognize this goes completely against all the precedents, against all the other circuits. It's very strange, but they basically said, sorry, you can't do it. And just because it's always been that way, it doesn't convince us. So in state court, we're still going for it. In federal court, we probably can't. And then obviously a bucket for attorney's fees. The way we practice, we don't like to mix the class award and attorney's fees buckets. I think that leaves us in a position in negotiating against our client's interests. Some attorneys do that. We usually negotiate it separately. Obviously, we talked about notice to all the class members and court approval. Options for class members, and this can be a lot of fun. First is they do nothing. If they do nothing, they may automatically get a check in the mail or a coupon in the mail, or they may get nothing and have their claims released without getting any benefit. They can make a claim under the terms of the settlement. Some settlements require that they return a form in order to get their payment. They can opt out. I'm going to talk about that in some detail here in a second. And they can object. If they think the class settlement is no good or not fair, they can object. And we objected to a class action settlement against a very, very large bank several years ago. And they paid our client about $150,000 to stop objecting. And so it can be very lucrative if you have a client who is a member of a class and thinks maybe I should object, and if you can find something wrong with the class settlement. There are professional objectors. They're huge pains in the asses who go out there just to disrupt class claims and class settlements just for a free handout. That is not something that I would ever be interested in, because we've seen them. But to the extent that there is something wrong and your client's a party to it, yeah, you should object. Next slide. What does it mean to opt out? If someone opts out, they're out of the case. They're no longer a part of the class. They can forget about everything. They can bring an action on their own, but they don't have any right to the class claims or anything that's recovered. If they don't opt out, generally they're in the case, they're bound by the settlement, they're prohibited from taking any further action. So opting out can be very important. If you have a claim and you filed it and then you find out there's a class action out there for something similar, make sure you opt out of that class action, or you could be in the middle of litigation, have a defendant come to you and say, hey, your claim's not worth anything because you didn't opt out, and now you're bound by the settlement. So it's always important to keep an eye out. Defenses, non-class issues, arbitration clauses. This is the easiest way to kill a class action. However, in Bateman versus Verizon, we fought against Verizon, who tried to use a class waiver or an arbitration clause, and we won. The second BCA, who obviously was interpreting contract law, which is Florida law, said that an FCCPA claim just does not have a significant relationship to the customer agreement and therefore is not arbitrable. So we do fight arbitration clause fights. I suspect they're fixing the language in them as we speak from a corporate perspective. So arbitration's a class killer, but we do fight it. Fraud, if there's any sort of fraud claim, it has too much of an individual reliance element. And the final one, which defendants often raised, is they just simply say, hey, you can't ascertain who all these people are. And so that's one that always scratches my head, because usually they make that argument, we get a class certified and suddenly they know exactly who all the people are. But that's a huge defense in a class claim. So I'm going to touch on 3 cases real quick. This is the kind of don't do this list of cases. These are all very recent. I would say these are the last 6 months. Trishell versus Midland. This was a standing issue that a lot of us are familiar with under Spokio. In that case, the plaintiffs had received correspondence that appeared to be misleading. However, the plaintiff said, we were never misled. We were never confused at all. We just knew we had a lawsuit, and so we brought it. And the court said, nah, that's not enough. That's nonsense. There is a circuit split under this issue on whether a simple violation of a statutory right does give standing as a concrete harm. The 11th Circuit has taken the approach it does not. It seems as though the easiest thing to do is simply make sure your plaintiff says, yeah, I was confused, I was a little frustrated, I was upset. And it defeats this whole argument, or just file in state court where standing is determined under a different standard. Next is Moransky versus Godiva. I believe this was last week. This is something similar. I think class counsel was trying to be smart and say, hey, there's no individual issues, there's no individual damages, no actual damages. Our claims are statutory in nature. We're not even requesting any recovery for any personal injury. The 11th Circuit again said, hey, there's no standing. What's interesting about the Godiva case is that it was after a class settlement, and the standing issue was raised by an objector to the settlement. And I don't know anything about this. I have no insider information, but it seems to me that a defendant who had to reach a settlement in the millions of dollars because of potential risks of the lawsuit, and then who couldn't argue that there was no standing because of that settlement agreement, maybe would benefit from an objector who was not seeking any financial benefit, but raising a standing argument. And maybe there was something going on there. But certainly an interesting kind of legal question of an objector raising a standing issue when they had no benefit, because most objectors just want a check. And then the last case I want to raise is that Johnson versus NPAs. This is when the court eliminated the extra financial benefit that most class representatives were getting in federal class actions, called an incentive award that was awarded to class representatives just for saying, hey, thanks for being so strong and bringing this to the court's attention and getting resolution for all these people. The 11th Circuit basically said, no, they get what everyone else gets. And so it is suspected that that's going to be a bit challenging to get class representatives. I don't think so, because I try and make sure my class representatives are motivated by their willingness to do good. And there's still certainly a lot of incentive that a individual settlement with the risk of a class action hanging over defendant could also benefit them. So I don't think this is going to have the chilling effect a lot of people worry about. Also, file in state court, not be subjected to this. And so I don't worry about any 3 of these cases, but there are definitely things out there to kind of show you what's going on. Any questions or concerns? Call me, email me, let me know. Like I said, I'll make my whole inventory of cases available. I'll send you whatever you want to send. I'm happy to co-counsel. I'm happy to bring people in on cases and work with them and let you guys have a seat at the table the whole way through. I actually really enjoy that. Really enjoy working with other people. So, hit me up.
Well, thank you, Brian. That was wonderful. We've hit Brian up quite a few times, and I've enjoyed all of our cases together. So the CLE credit for everyone is 2007275N, capital N. And that's again 2007275, capital N. You're always welcome to email me as well if for some reason it doesn't work or you have any problems there. I'm going to go ahead and stop the sharing, and then we can see if we have any questions from anyone. Let's see. If anybody has any questions, go ahead and post them here, and I'll go ahead and ask Brian. Wait for a couple minutes. We all should be outside. It's really nice today, Brian. It's like 70 degrees out.
It is. I was going to walk around downtown and see if there was any fun things to be seen with the election going on.
Well, we still have everybody still online, so I'm going to wait a few minutes. Nobody's logged out yet. See if anybody's typing in any questions. So doesn't look like we have any questions. Well, thank you again, Brian. I really, really appreciate it. And hopefully some of our members will be more interested in doing class actions, maybe with you, maybe with someone else in the future. And appreciate it very much. Thank you.
Thank you for the invitation.
All right. Bye-bye.
Bye.